Good afternoon, everyone. I'm pleased to introduce our panel. On behalf of NYU's Center for Global Affairs, I'd like to welcome the audience and the speakers. Since its founding, the Center for Global Affairs has been preparing global citizens to make a positive impact on the world. We do this primarily through our two graduate programs, one in global affairs and the recently launched MS in Global Security, Conflict, and Cybercrime. This panel is also co-sponsored by the Permanent Mission of Liechtenstein to the United Nations, the Global Institute for the Prevention of Aggression, and the International Criminal Court Committee of the American branch of the International Law Association. To start us off, I would like to introduce Ambassador Wenaweser. He is the permanent representative of Liechtenstein to the United Nations and, among other appointments, has served as president of the ICC's Assembly of State Parties. He chaired the Special Working Group on the Crime of Aggression and chaired the ICC Review Conference in Kampala, Uganda, where the Crime of Aggression Amendment was adopted. Liechtenstein also hosted the meetings of Council of Advisors on Cyber Warfare and the International Criminal Court's Rome Statute, which has recently put out this important new report entitled the Council of Advisors Report on the Application of the Rome Statute of the International Criminal Court to Cyber Warfare, and we'll put a link to the report in the chat in a little bit. Ambassador Wenaweser.
Thank you so much, Jennifer, and it's a really great pleasure to be here with all of you, and an honor for me to offer some brief opening remarks to introduce the project, on which you will hear in much more detail from our panelists, who of course have been working on the Council of Advisors. The Council of Advisors was an initiative that we put together as the mission of Liechtenstein, but with support from a good number of countries, and I want to mention them at this point. They are Argentina, Austria, Belgium, Costa Rica, the Czech Republic, Estonia, Luxembourg, Portugal, Spain, and Switzerland, as well as the Global Institute on the Prevention of Aggression. So we found these partners to put together the Council of Advisors, and we did so because we thought it was extremely important and timely to take a look at how the Rome Statute does apply to cyber warfare. The application of international law, much more broadly speaking, is, as you know, subject of an intense ongoing discussions inside the UN system as well as outside. There is a general agreement that international law does apply in cyberspace, but how, to what extent, under what circumstances, and so on, that is the case is a question of ongoing debate. We found it extremely important to take a very specific look at the Rome Statute. The Rome Statute of the International Criminal Court has, of course, not been universally ratified, but it has found a very strong support among states, and is undoubtedly one of the key achievements in the history of treaty making, and certainly one of the biggest achievements in this respect in the past few decades. Even those who have not joined the Rome Statute look regularly at the definitions of the crimes in their examination of international criminal law, and those parts of the Rome Statute in particular have proven to be extremely solid and very widely accepted. We did believe and continue to believe that looking at how this particular set of law does apply to cyber and cyber warfare is something that is very much worth examining, both because it is of relevance to the broader discussion, how international law applies to cyber, but also because it illustrates the strong ongoing relevance of the Rome Statute, of which we are very strong supporters. The entry point for us as a mission as the mission of Liechtenstein was in particular our interest in the crime of aggression. And Jennifer has alluded to that when she talked about some of the things that I have previously done. But we did, of course, find it at the same time very important and really of the essence to take a broad look, to take a look at all the crimes covered in the Rome Statute. And we were extremely honored and pleased to get such a strong response from outstanding experts in the field of international law that sat together with us to put this report together. So you will be hearing from members of the council, and I very much look forward to this conversation. Again, thank you so much to you, Jennifer, and thanks to all the panelists. It's a real pleasure to see you again, and I look forward to our discussion. Thank you.
Thank you, Ambassador Wenaweser. I would like to now introduce Professor Pano Yannakogeorgos. He is Clinical Associate Professor at NYU Center for Global Affairs and the Program Director for the Master of Science in Global Security, Conflict, and Cybercrime. Prior to coming to CGA, Professor Yannakogeorgos spent nearly a decade in government civil service with the US Army Air Force, finishing his tenure as the founding dean of the Air Force Cyber College. Pano.
Thank you, Jennifer, and thank you, Ambassador, for your comments as well. So it's a great honor to be here to kind of provide some initial technical context setting remarks on where technology has been and where it's going, and why the work of the Council of Advisors, as well as other international legal efforts to kind of shape how states behave in cyberspace are critically important to societal stability and global stability writ large. So I'll start with the 1800s, which is an odd time to begin cyber discussions, because most of us think of cyber as a tool that is used by states to project, maintain power, communicate, and command and control in pursuit of their national objectives as something relatively new. However, cyber, if we take it to its historical extreme, begins with the introduction of the telephone, which was an evolution from other telecommunications technology immediately preceding it, being the telegraph. What the telephone did is it allowed people to interact with people across the world in real time. It wasn't signals that flowed across wires and eventually wound up in someone's hand in a piece of paper. It enabled people to hear the voices that they were familiar with and understand and interact amongst themselves. International organizations were developed around the management of the telephone at the commercial level, but also to kind of help guide how nation states were to utilize this technology. So things like cutting undersea cables and things like that were frowned upon. Moving on in history, we started to develop the internetworking technologies that exist today and are very familiar to us. The pipes and wires that flow across the ocean and the satellite signals that enable global flows of information that enable humans to communicate, but increasingly have also allowed humans to control physical things. So in the 1980s, we saw a huge uptick in the exploitation of cyberspace and domain by criminal organizations, as well as nation states who had started to dabble in this as a domain of espionage. As more and more records were being stored in digital form, nation states were incentivized to go after the information that was important to them wherever it was. 2007 really signaled a strategic turning point in how nation states, alleged or otherwise, and used cyber operations in pursuit of their national objectives. So when Estonia, a country that is highly reliant and dependent upon digital technology, suffered a distributed denial of service disruption that took its digitized society offline for about a week. It was kind of the first time when we saw the ability for a nation state to cause mass disruption at a societal level. But this was targeting communication flows that are more or less similar to those with the communication flows that began with the telephone, albeit with audio-visual added on top of that interactive audio-only communication with a telephone. 2010 signals another significant time in cyber history when Stuxnet was now revealed to the world as a tool that had been used by nation states allegedly to pursue their counterproliferation objectives by sabotaging and degrading Iran's illicit nuclear program by using code to harm machines. The story only gets worse as nation states as cyber war capabilities start to proliferate amongst great powers, but also other countries, small and large, around the world. We've started seeing more and more activities that are causing these sort of societal, disruptive, and physical harm and destruction within critical infrastructures. So Colonial Pipeline in the past year resulted in the Eastern Seaboard and the United States not having access to fuel. A water treatment facility in Florida had been intentionally targeted by hackers in order to manipulate the treatment of water and potentially could have caused a mass poisoning of the local population had astute cybersecurity personnel not caught on to what had been happening. But all these sorts of targets are very hard to understand, hard to unpack, and need teams of engineers, electrical engineers, as well as computer scientists to really create effect on them. So the work of the Council and other international legal scholars that are aiming to try and signal what good and bad behaviors are in cyberspace will only become increasingly important as smart cities and Internet of Things become embedded across society. Because the level of skill that is required to cause these physical harms and destructive kinds of abilities will decrease, and the potential for mass effect and destruction may increase. So with that kind of pessimistic view of where cyber is headed, I wanted to pass it back to Jennifer and continue with the legal discussion for today's afternoon.
Thank you, Pano, for providing that discouraging introduction of where technology is leading us. I will now turn over the panel to Professor Noah Weisbord. He is Associate Professor at Queen's University School of Law in Ontario, Canada, and he will moderate the panelists, who are all welcome to join us on screen now.
What a pleasure to be here. It's great to see the panelists again and to hear the introductory remarks. Thank you for all the attendees. I see there's quite a good audience, and I hope you have a dynamic experience when you listen to these world experts talking about aggression, genocide, crimes against humanity, and war crimes in relation to cyber. So I'll just introduce the panelists very briefly so we can jump right into our discussion. First of all, we have Klaus Kress, Chair for German International Criminal Law and Director of the Institute of International Peace and Security Law at the University of Cologne. And Klaus is also an ad hoc judge at the International Court of Justice. We have Ona Hathaway, Smith Professor of International Law and Counselor to the Dean at Yale Law School. Charles Jallow is a member of the UN International Law Commission and a professor at Florida International University and my study partner in law school. Matthew Cross, Appeals Counsel at the Office of the Prosecutor of the International Criminal Court. And last but not least, Jennifer Chahan, Director of the Concentration in International Law and Human Rights and Clinical Professor at NYU Center for Global Affairs. She's also the newly named convener of the Global Institute for the Prevention of Aggression. So I have some questions for each of these panelists. Preliminary question, and then we'll launch into our discussion right away. And maybe if it's okay, then I'll start with Klaus. Klaus, would you please set the scene for us? What's the significance of the crime of aggression in the regulation of cyber operations? Crime of aggression.
Thanks very much, Noah. It's a pleasure to be here gathering with this wonderful group of panelists. Thank you, Ambassador Wenaweser, once again for your initiative to bring us all together and to provide such a constructive and collegiate framework which helped us to draft this report, the cyber report, which is now finally released. And Jennifer, thank you so much for organizing this event. And I'm very happy to take this occasion to congratulate you on your recent assumption of the position of the convener of the Global Institute for the Prevention of Aggression. An important position which will no doubt flourish under your service of office. Noah, on your question, this report, as it has already been said, it deals with the question of applicability of all the crimes under the ICC statute to cyber operations. And this is clearly a very warranted approach, not to let any of those crimes established under customary international law and included in the ICC statute aside. But it is meaningful that the crime of aggression is situated first. And I believe it is meaningful for two reasons. The first reason, I guess in anticipation, has been answered already by our technological expert Pano in his very helpful introductory remarks, because he has rightly pointed us to precisely those destructive capabilities that have more and more come to the fore of the international attention, which make us speak in lay terms about cyber war and cyber warfare. And it would have been quite surprising if the crime of aggression would not appear and would not figure prominently in that respect. But second, there is a reason why I believe it is meaningful that the crime of aggression is situated first, which has to do with a still persisting mindset, both among political actors, but unfortunately also among parts of international scholarship. And this mindset tends to ignore the fact that the crime of aggression is firmly part of the international criminal law landscape and has formed part from the beginning of the crimes under the jurisdiction of the ICC, and that its jurisdiction has been activated recently as from 17 July 2018. And just to quote from one recent statement, official statement, to make it apparent to the audience why I am saying this, that we are not quite there with our mindset where we should be. In the recent statement issued by the High Representative Josep Borrell on behalf of the European Union on this recent International Criminal Justice Day, so this year, the first paragraph reads, and I quote, "Every 17th of July, we commemorate the historic adoption of the Rome Statute of the International Criminal Court in 1998 as an important moment to reflect on the importance of fighting impunity and bringing justice for the victims, and now I emphasize, of the most serious crimes, genocide, war crimes, and crimes against humanity." Full stop. There is no doubt that these three crimes mentioned are among the most serious crimes. There is no doubt that they form part of the crimes under the ICC's jurisdiction. But it is striking and odd that in a statement, a formal statement issued by the European Union, the fourth crime, the crime of aggression, which after all historically was at the forefront, which after all was considered by no less than the Nuremberg judgment as the supreme international crime, is completely ignored. I don't think there is much use about discussing today whether there is a supreme crime under those four crimes. But to ignore one among the four is probably not a very wise and balanced approach. And for this reason, I believe it is useful to, so to speak, set a gentle counter message to this still prevailing mindset. Now, on the crime of aggression, I only wish to deal, so to speak, in opening our discussion following your general question, Noah, on the question of general applicability, and then a few words on the question of how the concept of use of force applies to cyber operation. The much more difficult question, I believe, the threshold question, which is specific to the crime of aggression definition, this I leave to my esteemed colleague, Professor Hathaway, who will tell you everything about this. Now, as regards the question of applicability, it was so important, I believe, that this group looked more deeply into it, because precisely at that point, in the course of the discussion before we started working on this report, doubts had been expressed. Doubts about whether this new definition or this newly formulated definition in Article 8 bis would apply to cyber operations at all. And there were criticisms that, so to speak, at the moment of the adoption of the definition, it already proved outdated because it did not deal with a type of destructive operation that, as Pano told us, was of so high relevance to contemporary events. So this is what our group looked into, if I may say, first of all. And where did these doubts come from? I believe, first of all, because people tended to look very much at the list of specific acts of aggression that you find in Article 8 bis paragraph 2, and which obviously was taken from Resolution 3314, adopted in December 1974. And in this list of acts of aggression, indeed, the word, the term, the concept cyber operation does not appear explicitly. Now, what is the answer to this doubt, which on a prima facie look seems to have some merits? There are two answers to it, which together, but also alternatively, provide compelling reasons, I believe, for the position that our group has unanimously taken, which is that in principle, this definition, despite and contrary to the doubts, does apply and can apply to cyber operations. So what are the two considerations? First of all, this report states, and I think very rightly so, that the list of acts of aggression in Article 8 bis 2 is not an exhaustive list, but it is an illustration of the broader concept of use of force. So that first of all, in order to give a meaningful interpretation, we have to turn to the concept of use of force and to inquire whether this concept, this generic concept, can apply or not to cyber operations. And if we here, as our group suggests to do, adopt the approach which I would say is clearly and rightly so prevailing nowadays, an approach which has been adopted by the ICJ in its jurisprudence as well, not to look so much to the instruments, to the means used by states in, so to speak, using coercive means, but to the effects of a certain action. Then, starting from the premise of such an effects approach, there is nothing in principle that would suggest that the concept of use of force cannot apply to cyber operations, always provided that physical effects result from the use of cyber techniques. And we have heard from our expert a minute ago that such physical effects may well be the result of cyber operations. Second step of the analysis, the list of examples, as I said, is only illustrative, so it leaves room on a, so to speak, subsidiary basis to apply the generic concept of use of force. But even if this was not true, even if one considered, as some colleagues do in the relevant international scholarship, even if one did consider the list of acts included in Article 8 bis to be exclusive, to be enumerative, even then, the fact that the concept cyber operation is not used explicitly does not prevent us from reasonably interpret a number of concepts used, like attack, like the use of the concept of weapon, to cyber operations without unduly stretching the meaning of those words. And that has brought us, and I will leave it here to pass it over to Ona. This has brought the group to a first, as I believe, very important statement and finding. Even though the concept cyber operations is not used explicitly in the definition, it applies through the generic concept of use of force and through a number of concepts used in the lists, the exemplary, the illustrative lists of acts of aggressions in Article 8 bis 2. It applies to the extent that certain destructive, i.e. physical effects result from those operations. Noah, I give it back to you at this point.
Thanks very much, Klaus. That's perfect. That sets us up great for the next question I wanted to ask. This one is directed at Ona. I'd like to get into the nuts and bolts, if that's all right with you. When does a cyber operation cross the threshold and become crime of aggression?
Thanks so much, Noah, and thanks for having me here to join this wonderful group. So Klaus, I think, very helpfully laid out the kind of basic framework here. And as he rightly said, there was agreement among the group, and I think pretty wide agreement within the scholarship and among international law scholars, that that the concept of use of force applies to cyber, and that jus ad bellum applies in the realm of cyber, which had at one point been a kind of open question, but today I think is rightly thought of as settled. And there was also agreement among the group that the way to assess that is look at the effects of the cyber operation. So this is sometimes referred to as the effects test. Look at the effects of the cyber operation and see if the effects of the operation are similar to the kind of operation that would meet the standard for a violation of Article 2.4. So, and that's widely agreed upon, and in particular to look to the question of whether, in looking at the effects, we look at whether the effects are not just sort of deletion of data, but there was a wide agreement that it requires some kind of physical effect. Now, the harder question comes in when we talk about the threshold clause. So, under the Rome Statute, in order for a use of armed force to meet the threshold of a manifest violation, which is what's necessary for a crime of aggression, it has to be a manifest violation of Article 2.4 of the UN Charter. And that's as justified by its character, gravity, and scale. That then becomes somewhat more difficult. And there was some agreement and there was some disagreement. And I think the report sort of fairly reflects the areas in which we have kind of general agreement. And I think many of the areas that Klaus very helpfully laid out are areas in which there was agreement. There was no dissent on that matter. But the question as to what meets the manifest violation requirement, the threshold clause for the crime of aggression, was somewhat trickier as a topic for us to work through. So first, I think everyone agreed that a cyber operation that results in loss of life or injury to human life would reach the level of manifest violation of the prohibition of the use of force. That's an area in which there was pretty wide agreement. The question really came in on the question of whether large-scale physical destruction or significant physical destruction that did not lead to physical injury or loss of life could also meet the level of a manifest violation. And I think that part of the reason for the lack of consensus in the group is just a reflection of a lack of consensus in the broader community of international legal scholars. The states who have expressed views on cyber and the application of use of force law to cyber haven't really yet fully articulated their views to this level of this fine-grained level. And so we don't have as much clarity about where the law really is on these matters. And so that's an area where we had a range of views about how far the manifest violation standard would extend. I'll just add to this because I want to keep it brief so that we have a kind of exchange of views and have an opportunity for Q&A at the end. That one of the considerations that many people thought was important to weigh is a recognition that if we are excessively generous in applying Article 2.4 to cyber operations, that might also open the door to an excessively generous application of Article 51 to cyber operations. And part of the reason for this is that the United States treats Article 2.4 and Article 51 as effectively setting a similar standard, or effectively the same standard. So that if something is a violation of Article 2.4, the use of force that violates Article 2.4, the US position is that that triggers a right of self-defense under Article 51. Not every other state holds this view. In fact, the US is fairly unusual in taking this position. Most think that Article 51 sets a higher standard. But in any case, there is a concern that if we are too generous in applying Article 2.4 to cyber operations, that it could, down the road, lead to a situation where a state will be too quick to claim that there's been an Article 2.4 violation from a cyber attack, and therefore they have a right to respond under Article 51. And the response under Article 51 is not necessarily limited to a cyber operation. So once you have a right to defend yourself under Article 51, you have a right to defend yourself in whatever way you think is appropriate, as long as it meets the rest of the standards of jus ad bellum and jus in bello. But it doesn't have to necessarily be in kind. So it could mean blowing up a building and potentially killing people that way. And so I think the Council of Advisors was mindful of the not just thinking narrowly about the Rome Statute and the crime of aggression, but thinking about, because we're in a space we're engaged in some progressive development of the law, some wariness about what it would mean to progressively develop the law such that we treat significant scopes of cyber operations as violations of 2.4, and therefore maybe also violations of Article 51 triggering this right of self-defense. So I'll leave it there and look forward to the rest of the conversation.
Okay, thanks very much, Ona. I guess my next question should go to Charles. The members of the International Law Commission and states have been thinking quite a bit lately about crimes against humanity, widespread or systematic attacks against the civilian population. So when does a cyber operation amount to a crime against humanity, Charles?
Thank you so much, Noah. And of course, a big thank you to the NYU Center for Global Affairs, especially Professor Trahan and her colleagues for organizing this really important webinar today. It's great to be part of this project. It's been one of my delights to be part of the really fantastic expert group working on this issue over the last couple of years. And of course, Noah, my study partner, it's great to see you and see you moderating this panel. Since we don't have much time, let me go directly to the question that you asked me, which is really the question of how crimes against humanity defined in Article 7 of the Rome Statute could apply to the cyber context. For those who are not familiar with the crime, basically Article 7 of the Rome Statute sets out the prohibition of crimes against humanity. And I find this crime particularly important because if you look at the scheme of the core crimes in the Rome Statute, it is in many ways the widest available core crime in the statute when you compare it to genocide, war crimes, and the crime of aggression. And from the perspective of the Rome Statute, and Noah referred to the work of the International Law Commission, the definition essentially really would require for proof of crimes against humanity in relation to cyber conduct, the fulfillment of essentially two conditions. Firstly, you must have that widespread or systematic attack against the civilian population. This is the so-called contextual threshold. And secondly, you have to show that one of the underlying prohibited acts, such as murder, extermination, or persecution, was committed by the perpetrator. Of course, within the Rome Statute system as a whole, there is a provision, Article 22, which basically provides that the definition of crimes must be strictly construed and cannot be extended by analogy. So for the purposes of cybercrime, the view of the council was that the conduct must be prosecutable in the ICC, must be one of those enumerated in the statute. So you're not going to bring in, if you will, new crimes through the back door. The Rome Statute sets the base and makes that very clear. Now, specifically when it comes to cyber warfare, the view that we took in the council's report was that the cyber warfare must be, or cyber operation really, must be part of a collective act that satisfies the contextual elements in Article 7.1, as well as the definitional element set out in Article 7.2. And of course, this would be really requiring that the attack be committed as part of, as Noah said, a widespread or systematic attack directed against any civilian population with the knowledge of the attack. And such an attack, of course, must be carried out, must be involving the multiple commission of acts referred to in paragraph 1 against the civilian population in furtherance of or pursuant to a state organization or policy. All of this add up to, in terms of how crimes against humanity have been interpreted, to essentially about 5 requirements. Firstly, you must show that there's an attack directed against the civilian population. Secondly, that there's a state or organizational policy in relation to that conduct. Third, that the attack is of a widespread or systematic nature. Fourth, that there's a nexus between the individual act and the attack itself. And finally, the 5th element of knowledge of the attack. So if you break this down very quickly, because we don't have a lot of time, I would say the first point to stress is that a cyber operation with physical or violent effects may qualify as an attack based on traditional interpretations of the meaning of attack in international criminal law. Now, a cyber operation with non-physical effects may qualify as an attack within the meaning of crimes against humanity if it falls within one of the enumerated acts. And essentially here, the thought that the panel had was, if you have a cyber operation against a civilian population where the civilian population is the primary object of the attack, that would qualify. So that's just the first point to stress in terms of that those 5-part that 5-part requirement that I mentioned a moment ago. Second point, if you have a cyber operation that's either backed by a state or non-state organized actors, if you think about, a loose network of cyber criminals carrying out attacks, they may fulfill the contextual element for a state organizational policy, especially the organizational policy bit, excuse me. And now, obviously, a policy can be written down, but given the nature of cyber operations, as with other operations, they may be inferred based on the conduct itself. So it can be explicit, it could be written down, or it could be based on a contextual look at the circumstances, and that would then establish the policy requirement. Thirdly, a cyber operation on its own or in the context of other conduct could give rise to the threshold of widespread or systematic attack that's necessary to establish crimes against humanity. And I think Una talked earlier about how, if you think of it from the point of view of the crime of aggression, this could work. Well, it's very similar in the context of crimes against humanity. And she was talking about how if with use of force in Article 2.4, the prohibition and how it links to self-defense, you could have a combination, if you will, of behaviors that could constitute a cyber attack. So it constitutes an attack that will qualify as a crime against humanity. It could be, if you will, in the physical world with forces and the traditional test, but also using cyber operations. Fourth point is that a cyber operation must itself constitute one of the underlying attacks, and this must be established. And to qualify that, we thought that if you look at the whole range of prohibited acts in the Rome Statute, it's possible that you could have crimes committed through cyber-enabled means, but the more likely ones for the purposes of crimes against humanity would be torture, persecution, apartheid, and other inhumane acts, and that those will be particularly relevant. And the reason is, the feeling of the council was that these do not require physical violence against the civilian population. Now, it's interesting and helpful that Pano, in his opening earlier, talked about examples of, for example, an attack of a water treatment plant in Florida. And that caught my eye, not just because I happened to be on the council and we're discussing this issue. It's really like a live example, a timely example of a discussion, but because also of the significance of what was going to happen in Florida. And so let me just share a couple of things about that incident. This is an incident that occurred in February 2021 in a town called Oldsmar in Florida, where a hacker initiated an attack of the water treatment facility by adjusting the levels of sodium hydroxide in the water and essentially elevating it from about 100 parts per million, which would be the safe level for the community, if you think about water that's going through the mains, to 11,100 parts per million. So from about 100 parts per million to 11,100 parts per million. Why is this significant? About 50 miles from where this incident was occurring would be the Super Bowl. So if it had been successful, basically the attack would have increased the amount of sodium hydroxide to a highly dangerous level in the water supply. And the only reason why that was averted was that there's an employee who noticed that the levels had gone up to such a degree, and actually they took the countermeasures in relation to that incident. This is really scary, but apparently it's not isolated. This is in February 2021 in Florida. Well, Israel in April 2020 reported, its National Cybersecurity Directorate reported that there had been attempts to basically attack and control through cyber means wastewater treatment plants, pumping stations, and even sewage facilities. So it's really quite significant and dramatic. And so it shows the relevance, if you will, of this kind of thinking that we were trying to do in the council. And of course, with other scholars in the international legal community, in terms of how the existing law could cover, especially in relation to crimes against humanity, but also other crimes, could be relevant in the context of cyber operations. I know we don't have a lot of time, so I'm going to just stop there. No, I hope that gives us at least a flavor for what the council was thinking in terms of the applicability of crimes against humanity under the Rome Statute to the specific context of cyber operations. I look forward to the conversation. Thank you very much.
I'm glad you gave those examples. I had another one in mind, which was the recent attack on the hospital computer system in Newfoundland, where a bunch of patient files and appointments were deleted, including of people that were meant, this was just last week, I think, supposed to go in for cancer treatments and things like this. It's kind of hits this threshold question that Ona had begun to talk about, and also the crimes against humanity question, deliberate attack on the civilian population. So I wonder if the panelists would also maybe think about what would be a kind of a clear-cut case of aggression by cyber attack, or crime against humanity by cyber attack. What's a gray area case? Our next question goes to Matt. My question for you, Matt, is can a cyber operation, which is a hostile online initiative, amount to a war crime?
Thank you, Noah. And I think in some ways I have the easiest answer to give, because the answer is yes. And the application of the Rome Statute to cyber warfare in the context of war crimes is perhaps the most intuitive part of the analysis that the report undertakes. To some extent, the clue is in the name. For those who are familiar with the Rome Statute and Article 8, compared to the other crimes under the statute, Article 8 is a very intricate framework of a wide variety of different forms of conduct, which over time have been identified as war crimes, which is to say they're violations of international humanitarian law or the law of war. And so when we think about cyber warfare in the context of war crimes, the question is more which parts of the now in some respects quite old legal framework is amenable to cyber warfare and which parts are less so. And the report of the Council of Advisors does a very good job, both in showing those areas where it's clear that the statute may already be applied to conduct in cyberspace, but also pointing to areas in the statute itself where actually this may need to be made a little bit clearer, and areas where the state's parties may need to consider some further amendments to make that framework consistent, for example, between international armed conflicts and non-international armed conflicts. Very briefly, if I may, I'll just touch on 3 points which come out of the discussion in the report. And the first one really chimes both with Ona's remarks and with Charles's remarks and your comment just now, which is about thresholds. And obviously, from the examples that have been given, we know that cyber operations, which may really rise to quite serious levels, are occurring all the time. And the question is then, well, does that mean that every time one of these things happens, does that potentially create an international armed conflict if it goes from one state to another state? And the report highlights the broader debate which exists in general international law and the jus ad bellum, which Ona's also touched on, about whether or not there is a threshold in particular for the use of force which will trigger an international armed conflict, and if so, what that threshold might be, and therefore in which circumstances an act which occurs purely in cyberspace and doesn't necessarily have any physical harm, could that ever trigger an international armed conflict? And of course, in the context of the statute, you can't have a war crime if you don't first have the existence of a conflict. And so that, together with the Rome Statute's own admissibility requirements for sufficient gravity, tends to lead to the conclusion that if you have conduct which does not satisfy the thresholds either of Articles 6, 7, or 8 bis, nor does it necessarily produce physical harm or injury, perhaps of the nature that Charles described in terms of the attack on the water supply in Florida, then probably that's not going to be the kind of conduct which is itself going to fall for consideration within the war crimes framework either. So in other words, the report emphasizes that cyber conduct certainly can be a war crime, but this doesn't mean that you're going to see frequent or marginal cases in which conduct in cyberspace, for example, taking down a website or more technical instances in which harm is caused, is itself going to ever be considered in that framework. The second important thing proportionality apply equally in cyberspace, and therefore that it is possible for an attack on civilians or a civilian object to be treated as a war crime just as much as kinetic conduct, which causes the same kinds of harm but through purely physical means. The report stresses that cyber conduct will only be treated as an attack and therefore potentially fall within that conduct of hostilities framework if it amounts to an act of violence, and therefore it excludes things like espionage or similar kinds of conduct, even if they are directed against civilians or the civilian population. And obviously there might be potentially significant human rights concerns with regard to that conduct, with regard to privacy or other protected values, but they wouldn't fall for consideration. When we think about acts of violence, we might also think about cyber acts which have violent consequences. So not just those kinds of acts which may, if you like, very immediately cause physical damage or civilian injury, but which might also neutralize certain electronic systems which might be critical for human survival in various ways. Just as a final aside in this context, and importantly for those of us who are, if you like, international criminal lawyers more than cyber lawyers, the report makes some very helpful and general observations about the apparent asymmetry which exists in the Rome Statute between the crimes which apply to international armed conflict and the crimes which apply to non-international armed conflict. And in particular, the report builds on the one hand on some of the jurisprudence of the ICC, which recognizes that indiscriminate attacks in non-international armed conflict are still prohibited, even though the relevant provision of the Rome Statute, Article 82E1, is not entirely clear on its face about that. But it also points to the fact that states should consider whether or not, for example, the crime of disproportionate attacks, which applies in international armed conflict, should also apply and be criminalized in non-international armed conflict. That is the position in customary international law, but at present that's not part of the Rome Statute. And finally, just on the third point, the report is very interesting in that it begins to venture also beyond the Tallinn Manual and to point to other kinds of harm which may fall for consideration of the war crimes framework as well. So, for example, the report suggests that some kinds of civilian data, such as healthcare data, might be regarded as an object which should be protected from deliberate attack, even in and of itself, without there necessarily being associated physical damage or harm. And again, it was interesting in that context, Noah, that you referred to the hospital in Newfoundland, where by the sounds of things, that seems to be a very pertinent example of that being a concern. And again, in that respect, although the report goes beyond the Tallinn Manual in that respect, it does build on other scholarship out there, for example, at the University of Oxford in the United Kingdom. And I think probably at that point, I'll just bring it to a close for now.
Thanks a lot, Matt. If I remember correctly, one of the kind of more unsettling parts of our discussion had to do with genocide in relation to cyber. So maybe Jennifer can take this one. Would you please explain, Jennifer, how a cyber operation could be a genocide? Yeah.
Thanks, Noah. Thanks for the question. And it's a great pleasure once again to speak with my co-panelists. It was a great pleasure serving with you on the Council of Advisors. And Klaus, also congratulations on your important new appointment as Special Advisor to the ICC Prosecutor on the Crime of Aggression. So first, let me start my remarks by saying what we're talking about here today is probably a very narrow set of what the audience might think of as cybercrime, huge amounts of which are occurring, and we're not addressing that. And even what is discussed in the media as a cyber attack may not qualify for what we talk about as lawyers when we talk of an attack meeting, in the crime of aggression or in the war crimes context. So just to differentiate, we're really talking about attacks where there would be serious injuries to persons, a number of people killed, serious destruction to property. That's kind of the easiest situation to envision meeting the Rome Statute gravity threshold. So Ona discussed the threshold in the manifest requirement on crimes against humanity, and Matt discussed the threshold for what is armed conflict. That of course, all of the Rome Statute crimes, you have to be in the Rome Statute threshold of gravity. I think just also one more general remark, what is very significant is all of us fully agree that the Rome Statute has applicability here regarding all four of the crimes, and no amendment is required. So we're saying they simply fit in the existing structure of the Rome Statute. Now, in terms of genocide, of course, you have the special dolus specialis. This is kind of the overarching mental state requirement of intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. And then you have the underlying crimes. And here I want to differentiate just initially between genocide that is done through cyber means or genocide that is cyber enabled. And I think for all of the Rome Statute crimes, you could have the crime fully committed through cyber, or you have a cyber-enabled crime. So that is cyber and conventional means, sometimes referred to as a blended attack, which I think we have already seen. So in terms of an example, Noah asked for of genocide and a cyber attack that would be genocide might be shutting down the cooling systems of a nuclear reactor that releases high levels of radiation, killing members of a protected group, let's say a national group, those in another state. Now, to qualify as genocide, it has to also meet the special intent requirements, so not an accidental release of radiation, for instance, but a very specifically intended release targeting those national group members. Without that requirement, of course, it might be one of the other underlying crimes. You might have a cyber-enabled genocide. For example, I think we already have one. This would be incendiary posts by, reportedly by members of the Myanmar military against those in the Rohingya group who are a different national, different ethnical and religious group from the military. So in this way, you have a social network tool turned into a tool for ethnic cleansing. And here, this would be cyber enabled because the killing and rape and other crimes were accomplished through more conventional means. In terms of some of the underlying crimes, so I think those are examples of killing. The report, the second underlying crime of genocide is serious bodily or mental harm. And the report goes to a significant discussion. Is serious mental harm enough to trigger the Rome Statute or to trigger genocide? But I just note that often the mental harm isn't by itself. So the report gives the example of a malware attack on the Uyghurs where their phones were hacked into. And this was coupled with surveillance already in place, including cameras equipped with facial and voice recognition and machine algorithms monitoring popular messaging and other internet activity, creating a prolonged sense of fear. That example is given. But of course, and the report does question whether solely mental harm would qualify. But I simply note, and this is in a personal capacity, it's not in the report, that what's happening regarding the Uyghurs includes rape, torture, enslavement, persecution, and imprisonment in large detention camps. So of course, this cyber element is just part of the greater totality of the harms being inflicted. The third underlying crime of genocide is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. That is basically a slow-moving genocide, and I think my prior example would fit into that as well. The fourth underlying crime of genocide is imposing measures intended to prevent births within the group. And the report gives the example of a disinformation campaign designed to dissuade or forbid members of another national, ethnical, racial, or religious group from procreating. And here I also note what is happening regarding the Uyghurs. I make this observation in personal capacity as we didn't go into the non-cyber parts of the crimes in the report, but there is a campaign of forced sterilization, forced contraception, and forced abortion that is occurring. The fifth underlying crime of genocide is forcibly transferring children of the group to another group. The report gives the example of oppression or dissemination of threatening material, including through social media platforms that compels members to transfer their children to another group. I note again in a personal capacity, because this was not particularly in the cyber realm, but Uyghur children are being forcibly removed from their parents. So just to say, I think that cyber-enabled genocide is occurring today. It demonstrates the significance of the report and the significance of putting all of this together. Of course, the goal of the Rome Statute is ideally not there to prosecute the crimes, but to deter the crimes. And I would say the first step in deterrence is getting the message widely known. that certain horrific cyber attacks actually fall in the current Rome Statute. So in this regard, I think the report is a very helpful contribution. I think it would be even more powerful if the Office of the Prosecutor, for instance, were to opine in a position paper on cyber attacks under the Rome Statute or cyber attacks that would meet Rome Statute threshold of gravity. That alone, that messaging could play a deterrence function, as could, of course, the prosecutor trying a first case if one of these seems triggered and falls within the jurisdiction of the court. So I'll end my remarks here. Thanks.
Thank you very much, Jennifer. Maybe would anybody like to respond to what's been said so far or to elaborate on your initial answer? It's a good opportunity now. But I know that maybe you have some things you'd like to unpack. You can just open up your mic if you want and fire away. And if not, I'll continue with some more questions. Yeah, okay. Well, one special problem related to cyber operations that we discussed, and this crosses all the various crimes, is the question of attribution. And I'm wondering if anybody from any of the advisors have any insights about how it's different to attribute responsibility, individual criminal responsibility, when it comes to cyber operations and cyber-enabled operations vis-a-vis kinetic. And if Pano's around too, you're welcome to answer as well. And the floor is open to anybody.
I can make an initial remark and then hope that others will jump in. So famously, one of the challenges in the cyber context has been the question of attribution, although it's always debated as to how much of a challenge really it is. And one of the more interesting developments that we've seen in the last few years has been a practice of coordinated attribution by states. So you see a number of states who make attribution statements within a day or two of one another, with a similar kind of condemnation statement, often attributing to a particular actor. But what's striking about this is both this kind of, it's generating a bit of a common law around what constitutes sort of permissible and impermissible behavior, because ordinarily these attribution statements not only attribute, but also often condemn the behavior of the state to whom the operation is attributed. But it is also striking that those attribution statements are rarely accompanied by a detailed technical analysis of the basis of the attribution. And that makes it challenging for criminal law purposes, because probably the reason for that is that many of these states feel confident enough to attribute, but the basis for their confidence is often information or technology that they have received through means that they don't necessarily want to disclose. So in many cases, it may be that they have their own malware on computer networks that they don't particularly want to make apparent. There may be other intelligence sources that give them confidence about the attribution that, again, they don't necessarily want to disclose. And so there is this tension between a desire to attribute the act for purposes of condemnation and purposes of kind of development of the law, and resistance to providing the basis for that, because doing so will disclose information that states don't necessarily want to have made available. And that's all well and good if all that we're doing is trying to kind of make a political point. It's not great if we're in a situation of having to build a criminal case. And so that I think is going to be an ongoing challenge that we're going to face, that states often have this information, they have the technology, they have the knowledge to have significant confidence to allow themselves to attribute, but to disclose that for purposes of criminal prosecution can burn intelligence sources or burn other kinds of resources that they're reluctant to give up. And so I think that's the tension that I see as motivating part of this, but others may have something else to add.
Jennifer, you wanted to weigh in?
Yeah, sure. So just to point out that in addition, I agree with Ona's remarks, that we often talk about attribution of cyber attacks to a country. So I think it's kind of obvious that when we're dealing with Rome Statute crimes, we need to figure out, potentially which computer, is the start and then who was operating the computer. So it has to get into a lot more granular detail. And then of course, the Rome Statute has different threshold requirements in starting a case, but ultimately, eventually, proof has to be beyond a reasonable doubt of all of the elements of the crime. So this is quite complicated. And I think it raises questions of, should the ICC be developing, and I would say now, these attacks are occurring now, developing internal expertise on cyber attacks and the Rome Statute? Will the court be able to simply rely on experts from countries, or is that not going to be sufficiently neutral? How is this going to play out in terms of developing the significant expertise that is going to be required? So I just put that on the table.
And making matters more complex is the fact that it's often non-state groups or groups that are difficult to connect with the state that are launching these attacks. A warehouse is left open on a particular state's territory. There's computers inside, there are coffee machines inside. People are invited, if they want, to go in and use the computers and the coffee, and then reportedly the attacks are launched. So Matt, for the Office of the Prosecutor, may be able to shed some light on this question as well.
Thank you, Noah. And just before I do, I should stress that probably the points I'm going to make now are in my personal capacity rather than on behalf of the Office of the Prosecutor. But I would say that the kinds of concerns we're addressing actually just underline the focus that the court has anyway. The kinds of issues that you're describing are actually issues which are common to most ICC cases, but perhaps just turned up a notch. So it's good, again, to think about these issues in this kind of context, because it reminds us of the kind of challenges that the ICC faces in the first place, and why it's so important that states and other actors cooperate with the ICC in order for the ICC to discharge its mandate. And as both Ona and Jennifer have said, one of the challenges of conduct in cyberspace is that the kinds of evidence that might be most probative are probably going to be the kinds of evidence which states have and effectively have a monopoly on having. And therefore, the court is going to depend on state cooperation. And sometimes that may go close to certain areas such as national technical means or national security, where they may not wish to provide that information. And as you know, Article 72 of the Rome Statute has a very robust mechanism but by which national security information is still protected and to some extent cannot be used by the court, even if otherwise the state has a cooperation obligation. So that's undoubtedly a challenge. The second interesting thing is that a lot of the time as prosecutors, we talk about crime-based evidence, i.e. the evidence that you need to prove that the crime itself has happened. And then we talk about linkage evidence, which is how you relate the responsibility for the crime to the particular person who might be on trial. Generally speaking, we tend to assume crime-based evidence is easier, because normally the fact that the crime has happened, the fact that person A was killed or object B was destroyed is usually reasonably easy to establish, and the mechanism by which it occurred is reasonably easy. Of course, with cyber conduct, even proving the crime base gets more complicated, because you have to prove the particular chain of events which led from the original conduct of the perpetrator to the consequence on the victim. And if we're talking about, for example, a global cybercrime whereby the data travels between multiple states and multiple jurisdictions, you can readily imagine you might have a much more complicated picture of the crime base. The third happier point, though, finally, is if you could get all of this evidence, a lot of the evidence that you might get here is going to be technical evidence. It's going to be data. It's going to be something tangible and real. And that does maybe sometimes, hopefully, save you from some of the problems you have with witness evidence, whereby people forget things or they become unavailable or the testimony isn't necessarily as consistent as you might like it to be. So I think on the one hand, cybercrimes really pose a challenge and they make us think about how the Rome Statute system can be made to work most effectively. But on the other hand, there are maybe some benefits if you could find the kind of evidence that you needed in order to bring the case in the first place. So good things and bad things.
Maybe that'll lead us into a discussion. Oh, here, Klaus, please go ahead.
Perhaps one more dimension that you alluded to, Noah, beyond the technical problems, from the legal dimension. You, I think, very rightly mentioned that in the cyber realm, we will be very often faced with conduct that is physically carried out by persons that do not formally form part of the state apparatus. So do not qualify as de jure organs of a state. And that leads to the legal dimension of attribution in international law, or perhaps even more fundamentally, I believe that cyber operations very strongly emphasize or place before us the place of non-state actors in current international criminal law through all those crimes that we have mentioned. And they raise distinct questions according to the definition of those crimes. And I'm just flagging them perhaps on crimes against humanity. Charles can elaborate a little bit. It starts from, so to speak, the one extreme, crime of aggression, where you need, and that's the only crime where you need that state conduct. So here, if we adopt the prevailing ICJ case law, you have a very high standard of legal attribution, quite irrespective of all technical problems. And I will not go into the details. When it comes to war crimes, Matthew, you have attribution, legal attribution problems on different levels. You will have, so to speak, indirect attribution problems as part of the qualification of armed conflict in order to ascertain whether you have interstate violence, interstate use of force as part of the definition of international armed conflict. You have to attribute acts to states on both sides. You have, when it comes to non-international armed conflicts, a question which is legally even less explored. How really do you, what is the current legal standard in order to attribute, legally attribute acts to a non-state organization as party to an armed conflict? And then you have a second level attribution problem when you apply the question, or when you apply the facts to the question whether a certain conduct is associated to an armed conflict, the nexus requirement. It's not necessarily the same type of legal attribution, but it is one that members of OTP will have to go through. And then, of course, when it comes to crimes against humanity, and I leave it to our eminent expert Charles, who knows it all from his long-standing work in the ILC, then, of course, once you enter the field of non-state actors, you come to this thorny question: where are we today when it comes to organizational policy as part of the context elements? So it is an overarching question under legal terms, Noah, that you have put to us, which adds to the complexity. The report has, I think it is fair to say this, the report was not so ambitious, I thought it would have been overly ambitious to give, so to speak, fine granular answers to all those questions. But I think it is also fair to say we have tried to flag and to identify all those issues in an analytically clear manner.
Charles, do you have any remarks in response to what Klaus has brought up, crimes against humanity and attribution?
Yes, Noah, let me just take a stab at it to join the conversation. I think it's actually fascinating to make this connection, which I think, Klaus, you laid it out so nicely in terms of it's a cross-cutting issue concerning the challenges of attribution with respect to the different crimes under the Rome Statute. So I guess as a preliminary point, one thing that is worth flagging is in our discussions, at least in relation to crimes against humanity, but I think more broadly even, we were focused on the question of individual criminal responsibility and mainly set aside questions of state responsibility, which of course become relevant for the reasons that everyone has given, you know, starting with Una's points and Jennifer and of course Matt and just now Klaus. And then so if you start from that point of departure, that what we were looking at is primarily focusing on the question of individual criminal responsibility, you say, okay, well, what am I left with, right? Because still on the international law, when you have an obligation under a treaty, there is a possibility, it is the famous draft articles of the ILC on state responsibility, where we say, okay, well, every internationally wrongful act can attract a responsibility for the state. And of course, we have this very nice chapter, like God bless him, right? Late James Crawford dealing with the very difficult issue of attribution. And in the context of crimes against humanity, if I can take that specific one, you set it out as well, Noah, that you may have instances where it's clear, of course, this is the point about the state conduct, but maybe borrowing the idea of a blended attack, you could have a state that is not itself carrying out the conduct, but actually acquiesces or looks the other way, right? And I'm sure folks in the audience will be familiar with examples of states that are alleged to be doing that, where they look the other way and they leave these individuals within the spaces of the state to go about carrying out attacks, including cyber attacks against other states. But it's interesting, the further point, that in the context of crimes against humanity, one of the big debates is, well, how far do we go? Is it just a state entity when there are entities associated with the state, or could they be loosely organized networks of individuals, militias, and this is the famous Kenyan situation, the Mungiki in Kenya, right? They were used by politicians who were very ambitious. They were trying to gain office. They, if you will, set them like having the dogs go out there to do the dirty work for you, but they are not formally part of the state. And the question came up before the court as to whether there is even jurisdiction for crimes against humanity. And of course, the judges said, well, we've got to look at this. And yes, non-state actors like this, working together, having some kind of hierarchy and organized purpose, could carry out crimes against humanity. So the conclusion was very clear on the part of the court. So essentially, we're bringing within the ambit of the Rome Statute system a crime that initially was started off as focusing primarily just on state conduct, at least in terms of the Nuremberg origins. This is where the famous Judge Carl dissent came from, right? That this is the Nuremberg origin says it's only states, when the states are acting, then you can have a crime against humanity. But I think it's fair to say that the law has evolved quite a bit to take into account the experience of the international community, where we now say, no, any group that's capable of carrying out this widespread or systematic attacks against the civilian population could carry out crimes against humanity. And by the way, that's the conclusion that was reached by the ILC back in 1996 when it was drafting the Draft Code of Crimes Against the Peace and Security of Mankind. Is the same conclusion that the Commission reached when it dealt with the question of crimes against humanity in the recent item, the draft articles for the prevention and punishment of crimes against humanity in 2019, sent up to the General Assembly. So it's an interesting question that I think is with us, but we'll have to see how that resolves itself. But ultimately, for particular purposes of cyber crimes, I think we have to grapple with it. And as Jennifer said, maybe the OTP should be thinking about a policy paper on this issue, right? So maybe I'll add my voice to that, because I think it'll be very interesting to do thinking, because we already know that these things are going on out there. I'll stop there for now so that we could get to the questions.
Jennifer, how would you like to do this? I see we have a bunch of interesting questions in the chat and we're nearing the end of the discussion. What do you think?
I propose that maybe the panelists view the questions in the Q&A and everyone picks maybe one they would like to address I was already viewing them, so maybe I'll start giving others a chance to look at them. And if you overlap, that's okay, because you'll probably have different answers. So I was looking at a question by Anonymous. Can you speak more about the role of social media platforms such as Facebook in IC charges for cyber-enabled crimes? For example, is it difficult to obtain evidence from them? Also, would they face any criminal liability? So I just, I didn't maybe make it originally so clear in my initial opening remarks. So crimes that have occurred solely internal to Myanmar are beyond the ICC's jurisdiction, as are crimes that are solely internal to China. So just to make that very clear, the ICC can only really proceed if at least maybe one element of a crime has occurred in a Rome Statute state party, which is what they're doing in terms of Rohingya who have fled into Bangladesh, which is a Rome Statute state party. So unless you can kind of frame that cross-border element, these cases, potential cases that I outlined in my remarks, are not necessarily ICC cases. But in terms of what is available on social media platforms, I don't have the technical. I think the IBA has much more of a project of how to take data off of the internet and establish kind of all of the requirements for preserving how the data has been collected so that one can authenticate it at trial. So there's a question of authenticating the information you obtain off of the internet, and there are those who have worked on this and have techniques for doing so. But the question, would a corporation face criminal liability? Well, there is no corporation liability at the ICC, so it'd have to be a question, can you pierce the corporate veil to get at, Facebook or something like that? But here I'm reminded of the Rome Statute threshold of gravity. And when you have incendiary posts, to me, and I think we've seen this recently in the United States with whistleblowers, et cetera, it looks like there needs to be a lot more regulation of social media platforms. I'm not the first to, I don't jump at thinking that they should wind their way to the ICC. I'm not sure that is going to be, the ICC is there for the gravest crimes of concern to the international community. I am not sure it's going to meet that, but I think it's important to look at more regulation for responsible conduct so we don't have incitement to genocide occurring on social media platforms.
Thanks very much. Anyone else want to take a shot at one of the other questions?
I can take a shot at the last question. So the last question says, with the complexities of cyber attribution and the debate facing state responsibility of cyber attacks, would the ICC be the ideal mechanism under international law for handling the jurisdiction of cyber attacks? And here I think what I want to do is take a step back for a moment and just remind our listeners that the ICC only has jurisdiction if there is no effort to prosecute for a crime in the host state, in the state in which that would be responsible for the violation. So this is the well-known principle of complementarity. So under the principle of complementarity, the ICC only has jurisdiction if the state has not taken action itself. And so by definition, then, the ICC is only stepping in cases where either a state is unable or for whatever reason not willing to prosecute for the cyber attack. Now, it's still a fair question as to whether criminal law jurisdiction is the best way to handle these things. And I would say, I actually think the answer more often than we might think is yes. In part because we've been too quick to think about responding to cyber attacks through a military response, through military weapons, or through active responses, either in kind. And I think reorienting some of our responses to cyber attacks more generally to a criminal law framework is a good idea, writ large, not just talking about the ICC, but thinking generally about how we want to respond to the growing use of cyber technology to interfere with operations of states and individuals and private actors. And so the ICC is part of that. And when you're dealing with something through a criminal law framework, you're less likely to be dealing with it through a military response. And I think as a whole, that's a good thing. Does that mean that every cyber attack is going to be appropriate to be dealt with through the ICC? Absolutely not. Even if the principle of complementarity would mean that that the ICC could proceed with it. But nonetheless, I do think that that having this as an available option in instances where there is effectively no other alternative is a good thing.
Okay, thank you very much. Perhaps I'll hand this back to Jennifer. It looks like we're nearing the end of our time. It's interesting to look into the future and to see kind of how this technology is evolving, and kind of the conclusion that I'm drawing from having listened to you guys is that the Rome Statute is capable of regulating cyber operations. There may be some weaknesses, but it is certainly capable of it. And as I listen more and more to you, I see where those weaknesses may be, but I think that we have the tools to confront what's ahead. So back to you, Jennifer.
Yeah, I saw Klaus unmute himself, so I didn't know. Klaus, we have 2 minutes if you had a quick response to a question that you wanted to make.
Well, I could give quick responses, but not if this would bring us over time.
I think we're cutting off in 2 minutes, which is kind of awkward.
Yeah, so then probably we have to leave it there. I just wanted to indicate my willingness.
So thank you so much to the audience and to the panelists for joining us. I think this was the start of a wonderful discussion. I commend Liechtenstein and all the states and the Council of Advisors. We only had a few of us on today, but I listed all of the council who participated in drafting this report, and all states, especially I think Liechtenstein and Ambassador Wenaweser, deserve to be commended for having the foresight. And, you know, I believe the idea for this, maybe Ambassador Wenaweser can correct me, did this come from Ben and Don Ferenc? And Ben, of course, our last living Nuremberg prosecutor. I think they were some of the impetus for getting us going in all of this. I think that's right. Yes, Ambassador Wenaweser, how did we get started?
Thanks a lot, Jennifer. Great discussion. Thanks, thanks everybody. Special thanks to you. Indeed, the conversations that I had with Don and Ben certainly were one of the triggers, one of the catalytic moments in doing this. And yeah, we're very happy where we are. We also know that we have a long way to go. We think this is you know, a very, very solid foundation for a discussion, but a discussion that needs to be taken forward. And I know we have great partners in this. So thank you all.
Great. Thanks, everybody.